Trump is not going to jail, ever. Sorry, there is no credible path for him to spend any time in prison for the crimes for which he has already been convicted or for which he almost certainly was going to be convicted in the future. He stalled, ran out the clock, and then became the referee again. And Donald Trump is going to be the president again. His criminal conviction and the 3 other cases were never really an issue in this election for reasons that boggle the mind. I guess mainly because America loves a bad boy. They're just not usually this bad. So what happens to Trump's legal cases now? Well, not to bury the lead, but they are effectively over. But I suppose in a morbidly fascinating way, it is interesting how and why each of these different cases is now dead. Now, to understand why, we first have to talk about presidential immunity. We've talked about this on this channel before, so this is a broad summary. But back in 2022, there was a congressional inquiry into Trump's role in the events of January 6th. The House Select Committee gathered evidence for 17 months, and Donald Trump declared his candidacy for the 2024 presidential election on November 15th, 2022, before the committee finished its report. The House Select Committee report was released on December 22nd, 2022. And 8 months later, the Department of Justice filed charges against Trump in Washington, D.C. This indictment, brought by Special Counsel Jack Smith, included 4 counts: conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights. Now, this led to a battle over the nature of presidential immunity. Presidential immunity refers to the legal protections that shield a sitting president from certain legal actions and liabilities while in office, and there are 3 points to remember as we go forward. First is that a president is immune from civil suits for actions taken as part of their official duties. This was confirmed in the 1982 Supreme Court case Nixon versus Fitzgerald, which held that a president was absolutely immune from civil damages for actions within the outer perimeter of their official responsibilities. Second, the presidential immunity does not cover actions taken before the president took office. This was established in Clinton versus Jones when the Supreme Court ruled that then-President Bill Clinton could be sued for alleged misconduct before becoming president. And third, presidents have broad immunity from criminal prosecution. This wasn't always necessarily the case. Before Trump was president, the general assumed rule was that presidents were not immune for criminal prosecution. However, there were caveats. The Department of Justice's official policy, outlined in memos from the Office of Legal Counsel, especially one in 1973, is that a sitting president could not face criminal indictment or prosecution while they were president, reasoning that it would interfere with the executive branch's ability to function. In 1973, Robert G. Dixon Jr., the then Assistant Attorney General, issued the memo called Re Amenability of the President, Vice President, and Other Civil Officers to Federal Criminal Prosecutions while in Office. And in that memo, the Department of Justice concluded that an indictment or criminal prosecution of a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions. However, it was always assumed that the sitting president could face criminal charges after leaving office once their term ended. Now, we'll talk about this particular DOJ memo later, because in this particular circumstance, Robert G. Dixon Jr. really screwed the American people. But that brings us back to the Trump litigation itself, because in Trump versus US, Jack Smith sought to admit testimony and records from Trump and his advisors about the events leading up to January 6th. The Supreme Court ruled, among other things, that the district court could not consider this evidence in proving their case against Trump. And the top line ruling from the Supreme Court was, quote, "Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority, and he's entitled to at least presumptive immunity from prosecution for all of his official acts. There is no immunity for unofficial acts." Now, we've talked at length about this particular decision on this channel, and it is much, much worse than it seems at first glance. But in sum, the decision significantly expanded presidential immunity and also left a lot of work for the lower courts to do in applying this new, never-known standard. And the court's ruling will impact all 4 of Trump's cases. And as much as it was uncharted territory about whether a president could be criminally tried for their actions, it is off the globe uncharted what happens when you prosecute a president and then he gets reelected. Fun. Yeah, so I guess if you're the president, you don't need a good lawyer because everything is just legal. But if you're not the president and you need a great lawyer, you can let my law firm, the Eagle Team, help. If you've gotten into a car crash, suffered a data breach, especially if you got a data breach letter saying your social security number has been hacked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery and get the best representation. So just click on the link in the description or call the phone number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below. So in looking at the prosecutions, let's start in New York, where a jury convicted Trump on 34 felony counts of falsifying business records related to hush money payments intended to influence the 2016 presidential election. During and after the trial, Trump raged against Judge Juan Merchan and his family. Judge Merchan then postponed his sentencing until after the 2024 presidential election to avoid any appearance of political bias against Trump. Now, these crimes were committed over 8 years ago and in aid of winning the first election in 2016. And now Trump has won another election. So what becomes of the case in New York? Well, Trump was convicted on 34 counts of falsifying business records, and each count is classified as a Class E felony under New York law, which carries a maximum sentence of up to 4 years in prison per count. But there was no minimum sentence, meaning that the punishment could have been just probation or fines. And while the law permits a maximum sentence of 4 years per count, actual sentencing varies depending on factors like the defendant's prior criminal history, the specifics of the events, and judicial discretion. And in some cases, defendants convicted of Class E felonies might get probation instead of incarceration, especially if they are first-time offenders or if there are mitigating circumstances present. And I hate to break it to you, even though Trump is barred from opening a charity or operating a business in New York, he's still considered a first-time criminal offender. And as of the time of this video, Trump is due to be sentenced on November 26, 2024. However, Judge Merchan gave himself a deadline of November 12th to decide whether the convictions should be overturned because of any of the immunity issues. Now, why would the immunity decision be an issue if the illegal conduct happened before Trump was president? Well, Trump continued to pay back Cohen for the illegal hush money payments after he was sworn in. And Trump's lawyers have argued that the evidence used to convict him includes official acts, and therefore it should be overturned. Now, Trump could in theory be sentenced to prison before he takes office in 2025, but that's simply not going to happen.
If you can't do the time, don't do the crime. Okay, time's up.
But New York procedure is weird, so let's talk to one of the best commentators on New York criminal law, former federal prosecutor Mitchell Epner. Mitch, what's likely to happen here?
Thank you, Devin, for that kind of introduction. My expectation is that there is no world where Trump will actually get sentenced 2 weeks later on November 26th on what is his currently scheduled sentencing date. There are 3 possibilities that may emerge from Justice Merchan's ruling. Possibility number 1 is that Justice Merchan will hold that the entire prosecution was fine. It comported with the restrictions set forth by the Supreme Court in Trump versus United States. And as far as he's concerned, the case can move forward to sentencing on November 26th. At that point, Trump will be able to stop the sentencing by taking an appeal, because under longstanding United States and New York precedent, when you have an appeal of an immunity decision, that appeal can be taken immediately. It's called an interlocutory appeal, and that will stop everything else in its tracks. Possibility number 2 is that Justice Merchan would rule that there were problems with the prosecution in the trial evidence that was presented, and on that basis, hope that it was required that there be a mistrial and a retrial. Obviously, if there's a retrial, then all 34 convictions would be vacated, but that retrial certainly could not happen before January 20th of 2025. And once we get to January 20th of 2025, nothing can happen until Trump leaves office, which, absent death, would mean January 20th of 2029. Possibility number 3 is that Justice Merchan rules that the indictment itself was fatally defective because it relied upon evidence that could not be used in a prosecution of a former president. And if that were to take place and the indictment were dismissed, that would end this case, because District Attorney's Office for New York would not be able to go back and get a new indictment because the statute of limitations on this case, which again goes back to things that happened in 2016 and 2017, would have long since expired. So that is why I think that nobody should be making reservations for a sentencing on November 26th. I believe that this case will, one way or the other, stop in its tracks on November 12th. Back to you, Getty.
Okay, so that brings us to the special counsel Jack Smith prosecutions in DC and Florida. Now, the district court regained jurisdiction of Trump's election conspiracy case in August in DC. However, because of the Supreme Court's ruling in Trump versus the United States, Judge Tanya Chutkan is now weighing whether Trump is immune for actions he took to overturn the 2020 election. Smith filed a superseding indictment on August 24th, 2024, and Judge Chutkan granted Smith's request to file a motion on the immunity determination and allowed Smith to file a redacted version of the public docket. Now, we covered these developments in the past, but the most important thing to know is that as president, Trump will have the power to fire Jack Smith. And Trump has already confirmed, quote, "I will fire Jack Smith in 2 seconds." Sources told CNN that Smith had no intention of quitting and would try to move the case forward between now and Inauguration Day. However, there are already reports that the DOJ will wind down the DC and Florida prosecutions to comply with long-standing policy that sitting presidents can't be prosecuted. Now, we'll talk about that more in a second. But if Jack Smith does stay on the job, does the president have the right to dismiss a special prosecutor? Well, basically, yes, though theoretically he would have to go through the DOJ. The Attorney General has the power to appoint or dismiss a special prosecutor. Now, in practice, the president would typically have to instruct the Attorney General to dismiss the special counsel. If the Attorney General refuses, then the president could theoretically just remove the Attorney General and continue down the chain of command until they find someone willing to carry out that order. This is what happened in Watergate, and this was a full-on constitutional crisis that we called the Saturday Night Massacre. But realistically, Trump is not going to appoint anyone who would refuse his order to sack Jack Smith. And included in the list of the people who've been floated to take over the DOJ from Attorney General Merrick Garland is Trump's favorite Florida judge, Eileen Cannon. Others include Trump's 2020 co-conspirator, Jeff Clark, Senator Mike Lee, who wants to go after the deep state, and Mike Davis, a lawyer who has promised to, quote, bring a reign of terror to DC. So yeah, if these cases are still ongoing, Jack Smith is 100% getting fired, if not prosecuted. And that brings us to Florida. Current judge and potentially future Attorney General Cannon recently dismissed the entire case against Trump, ruling that the appointment of Smith was unconstitutional. And although courts have previously ruled that the special counsel statute was constitutional, there is a conservative movement against the concept of special counsels, especially ones appointed by Democrats. Justice Thomas, in his concurring opinion in Trump versus US, opined that the special counsel statute was illegal, and Judge Cannon relied on that statement to throw the case out. Although prosecutors have appealed, it's not clear what will become of the case now. And even if the 11th Circuit ruled in favor of Smith, it's not clear the prosecution could continue without him. And Trump would also appeal the decision all the way to the Supreme Court, which might just rule that Smith was appointed illegally. Who knows? And in many ways, the Florida case contained the most serious allegations against Trump. He held classified national security documents in a semi-public area of his golf club, and the evidence is voluminous, and it's a tragedy that this case will probably never go to trial. And again, another thing to watch is whether a president-elect is covered by the same immunity as a sitting president. We've never had a reason to consider that question, so the Office of Legal Counsel has not issued any guidance on it. But there are several credible reports that Special Counsel Jack Smith is already reportedly in talks with officials at the Department of Justice to wind down his 2 prosecutions of President-elect Donald Trump. And if it were up to me, I'd probably continue the prosecutions right up until the moment that Trump is sworn in, and then make him fire the special counsel. This winding down process does kind of make sense. It's infuriating, but Jack Smith does have to comply with the OLC memo that says you can't prosecute a sitting president. So with respect to his cases, he faces 2 choices. Either dismiss the cases without prejudice or try to ask for a stay from the judges. Now, the stay would make sense, hopefully to toll the statute of limitations, because he's already filed the case, so if the cases are stayed, then the statute of limitations doesn't run. But if the cases are stayed, that means that the Trump administration could just come in with a new counsel from the DOJ and dismiss the case with prejudice, meaning that the case could never be refiled. So ironically, dismissing the cases without prejudice might be the best course of action, because then theoretically the cases could be brought up at some other time. The problem is that if the cases are dismissed, the statute of limitations would surely run during the course of the next 4 years, and then the statute of limitations would bar them, unless courts would create some sort of equitable tolling because of the fact that the president is sitting and cannot be indicted or prosecuted while being a sitting president. So there really is no good answer here. And of course, if the prosecutions continue until Jack Smith is fired, then Trump's DOJ could simply dismiss the cases with prejudice, and again, it's never being refiled. The one potential silver lining here is that under the special counsel statute, the special counsel is to prepare a final report at the conclusion of the case, and by winding down the prosecutions, that would probably allow Smith and his team to prepare final reports that I have no doubt would chronicle all the ways that Donald Trump broke the law. It's possible that Smith did learn his lessons from the Mueller report and might explicitly say all the ways that Donald Trump acted illegally and might chronicle all the evidence to support that. And possibly with the approval of the Attorney General, he could publish some such reports. And then in Georgia, the Georgia case suffers from all of the infirmities of the New York case, but probably more so. That case is currently stalled because of Fani Willis's relationship with her coworker Nathan Wade, which Trump says presents a conflict of interest. And the Georgia Supreme Court will hear that case on December 5th. But even on its own merits, that case probably wasn't going to go forward for a couple of years. But now with all of the arguments about Trump being a future sitting president, that case is almost certainly going to be stayed, if not dismissed outright. And of course, it bears mentioning that another nightmare scenario is that Trump could pardon himself. This is yet another unresolved constitutional question. And of course, those pardons would deal with any future federal prosecution, but not the state prosecutions. But honestly, that's not likely to happen unless it's on the way out the door, pardoning himself for all the things that he commits during 2025 to 2029, because he's just going to quash any federal prosecution. So he doesn't actually need to pardon himself. Now, if the lack of legal accountability for abject criminality has you eating your feelings, I sympathize, I'm doing the same thing, but you can have your cake and eat it too with today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook, so you can spend your day doing the things you actually want to do. Now, Thanksgiving is coming up, and I know I won't want to be cooking and shopping more than I need to around the holidays, and Factor is perfect for that. Plus, you'll never get bored with what you're eating. You can choose from over 35 different options a week, including ones that are keto, calorie smart, vegan and veggie, and more. And on top of that, Factor offers lots of snack options for when you don't feel like a full meal. Factor meals are fresh and never frozen, so I know I'm getting a high quality meal. Factor meals arrive at your doorstep pre-prepared and ready to eat in just 2 minutes. In the same amount of time that I could even think about going to a grocery store, my Factor meal is already done. Because sometimes I just want a good, healthy meal without having to cook. And it's a perfect workday dinner. And it's surprisingly affordable too, way less expensive than takeout or pricey delivery apps, and plus it tastes way better. And now Factor also offers Gourmet Plus meals as part of your weekly options. You can try meals that feature premium ingredients like filet mignon, shrimp, truffle butter, and asparagus. And I've really been into fish lately, and I love their surf and surf option, shrimp and salmon. It's always a bright spot in my day, but honestly, you can't go wrong with their normal offerings either. Factor's team of gourmet chefs creates each meal to help you feel your best all day long, and they really are extremely delicious. And Factor's flexible. You can pause or reschedule your deliveries at any time. Now, all this is making me super hungry, so click on the link below or the one that's on screen right now and use the code 50LegalEagle to get 50% off plus free shipping on your first Factor box. Again, just click on the link below or go to factor75.com and use the code 50LegalEagle to get 50% off plus free shipping on your first box. And after that, click on this box over here for more Legal Eagle, or I'll see you in court.